Welcome back, everybody. Aaron Keller here on the Law and Crime Network. We're in the midst of the William Knight case out of the Akron, Ohio area. This is a case involving a murder charge as the top charge and also an assault with a firearm charge against the defendant who's accused of shooting someone who was on a dirt bike that belonged to the defendant's family. Gary Gerstenfeld is an attorney. He's going to join us now to sort of deconstruct a little bit of that direct examination of the detective who was on the stand. Gary, you seem to have a pretty strong opinion about how drawn out that was, from what I gather.
Well, the now captain's discussion about the cell phone calls, the text messages, I think that is probably the most interesting part of the entire questioning. Talking about the motorcycle and the revving the motorcycle, he wasn't there. I'm not sure why the defense attorney didn't object more to that line of questioning. What is interesting about this case, and probably the most interesting thing about this case, because there's no real issue about whether, guilt or innocence in terms of whether, who committed the crime. The whodunit part is non-existent. Absolutely, William Knight committed this, whether it's a homicide that's involuntary or it's intended. That's going to be a question ultimately for the jury. The interesting thing about this case is the technology. Think about this. With the advent of cell phones and texting each other in real time almost, you can deconstruct, and I'm using your word, you can deconstruct everything that's happening as it's proceeding up to where the shooting occurs. This technology didn't exist 30 years ago when this, for example, this officer, when he first became a police officer and he was a regular street cop, they didn't have cell phones and they certainly didn't have text messaging. Now you're able to go back and look at and sort of follow as people getting closer. And like you said, 30 minutes prior to the shooting, we know where everybody is. We know what's happening. Very similar to a case that you all followed very closely, which was George Birch. This was the case in Wisconsin, where with technology, they were able to pinpoint by using dashboard Google where people were, and actually a guy who would never have been a target, in the case George Birch, for the murder of Nicole Vander Hayden, that never would have happened. So all this technology now is presented to a jury. It's almost like you're able to go back in time and follow the actors as they're proceeding up to the event.
Yeah, it's like having a rewind button. What's interesting about this one, Gary, is I think that these text messages could be taken by the jury to presume that the defendant was part of an escalation process against the victim here. You've got these text messages starting. There's not just one call to the police. There's call after call after call after call. And look, I realize that the defendant's family had something valuable stolen from them, but it's a dirt bike. I know that it's not the most expensive thing under the sun. It's also not the least. I get that. But, it's a dirt bike, and there's just call after call after call to police. It's let's get half the family down to help me, try to figure out what to do about this item. I understand that maybe they perhaps thought that it would disappear when an inquiry was launched.
Right.
But then it's kind of like now with hindsight, we're looking at this saying, gosh, you just kind of wish you could hit the pause button, let the police show up and do their thing, and then this entire shooting wouldn't have happened. But because we see it escalate, does that make the defendant look more guilty?
Well, it certainly shows sort of the state of mind, this frenziness that I think you're alluding to. What is the goal here? Is the goal to get a dirt bike that isn't worth very much? Is the goal to get the dirt bike back, or is the goal to punish the people that stole the bike? And it seems to me that's exactly what I think a lot of people are going to wonder, and they might not buy into this whole self-defense of others. Oh, we thought he was going to come back and perhaps harm some of the 3 family members who showed up to try to get this piece of property back. If it sounds like a punishment exercise, then the self-defense argument arguably just falls apart. They're rallying the troops to come to try to reclaim this bike, but they're also rallying the troops to try to catch the guys that did it. And of course, Mr. Knight is bringing his gun to this. The old stories: you don't bring a knife to a gunfight. Well, you don't bring a gun to I want to get my motorcycle back, and this is not going to turn into something bad. And it's interesting to point out that, you know, the gun was out well in advance of the shooting, according at least to the psychologist who spoke, Jolie Brams. This was the prior witness when she testified right before we went to Captain Laughlin. And she said, again, she looking back on the events and trying to understand it from Mr. Knight's point of view, he has the gun out. So, you know, not only is he showing up with the gun, but he has the gun out, and, you know, all this effort to get into and get these guys who stole your bike, and you have your gun already out. Again, that works against your self-defense theory, because obviously you have the gun out, you anticipate the possibility of using it.
Yes, you know, we had this particular officer talking about the revving of the bike because some of the testimony suggests that it was the defendant and his family who had their hands on the handlebars as part of that. I was trying to follow that yesterday. I got a little bit lost in it. So what I really wish the prosecutor would do here is sort of lay this all out in closing, tie that all together. Before we get to that point, though, I think what we really need is a dirt bike similar to this one somewhere as a demonstrative aid that shows jurors, okay, when you're revving this thing up and you just pop the clutch, it'll take off. So that's what happened, again, in the state's theory to this particular victim, is he was basically forced to take off like a bat out of you-know-where on this thing, right. And that's how he lost control. He didn't have control of the bike. He wasn't trying to, like, circle back around and run you all down. He was on a bike that was out of control. He was trying to get control of it. Part of the reason he laid the bike down and sort of slid under the car is anybody who knows anything about motorcycle safety knows that you lay a bike down as a last resort to either protect yourself from either even greater harm or to get something that is out of control under control.
Well, again, I don't,
you know, not the sort of actions of somebody who's going to come back and you know, try to do you harm as the defendant is characterizing here.
Well, everybody looks at the situation from two things. One, obviously, they're looking at it from their point of view, but also, two, now, in light of sort of the accusation of murder, they're now trying to rationalize why they did what they did and try to come up with as an innocent a reason for their conduct. I don't think the revving of the motorcycle or the getting away of the motorcycle is really putting anybody at risk other than losing the motorcycle, which then, in I think their mind, lessens the ability to get the guys that stole the motorcycle.
Well, you know, the characterization that the defendant is making is that this bike presumably wasn't out of control, or if it was, then the defendant, or excuse me, the victim got it under control and was going to come back and hit them with it. That seems to be the imminent threat that the defendant claims he was facing, and that's his rationalization for using lethal force here. But the state seems to be painting this very clearly as just an out-of-control bike with someone on it who's trying to get it back under control. And that's going to be something the jury needs to characterize.
Right, trying to get the bike under control so he can get out. He's trying to get away. He's been caught. Now he's trying to escape with the motorcycle. Yeah, as a self-defense or self-defense of others, how well that's going to play out, you know, I think as a factual matter, I think that there's probably not going to be that much division once you start getting into the actual witness's testimony about what actually happened. I think what you're going to get from a defense point of view is, well, with all this predisposition that Mr. Knight has, that he was he's overly protective of his daughter, and he had all these health issues, and he's emotionally distraught to begin with, and the loss of his wife Karen, that he's overly protective, and that this motorcycle revving up maybe brought back some bad memory, maybe when he was beaten by his principal, and this is why he reacted the way he did. I mean, that's the argument that they've got to make with what they have.
Well, we still have some testimony going on in court right now. Let's go back to court live in Ohio. We have reached the end of the day in the William Knight case out of the Akron, Ohio area, with the judge telling jurors to be back at 8:45 tomorrow. So testimony might start a little bit earlier again. as the judge also told them to come in at about 8:30 today. Gary Gerstenfeld is still with us here at the Law and Crime Network. I want to continue to break this down, Gary. So right at the end, we saw some pretty strong cross-examination of that witness, who's now a captain. Before he was a detective lieutenant, and you saw the different variations and flavors of those titles. But look, I mean, the defense is saying, hey, my client was there. He said that this victim was going to come back and harm his family, and that's what he said. And, you know, the officer had to agree with it, Gary, and the officer also had to agree that there was a egress, in other words, an exit, a way for this victim to get out of the situation by going down the street and turning. He could have taken off on the bike. But right. He didn't. So if this victim was really in harm's way, would he have not have gotten as far out of there as that gas tank would have taken him? That seems like a relevant point to me. What do you think?
Well, it's a pretty strong point, and ultimately for the defense, their best argument that they have, of course, is the fact that he wasn't charged. Talking about Mr. Knight, he wasn't charged with murder right away. It took a while. In fact, this probably will not be brought out during the trial, but there was an effort by Keith Johnson, the victim, by his family, to pressure the prosecution in the case to be more aggressive than what the original charges were. I like the way the prosecutor kind of passed that off, like, well, it's up to the grand jury to decide what the charges are ultimately going to be. The fact of the matter is the first responders, the police on the scene, they initially charged this as an involuntary, not as an intentional act. And so I think the cross-examination was good in bringing that to the surface, the idea that, hey, there was an alternative for the victim to have avoided. I think an argument also could be made, though, ultimately for the prosecution, that perhaps there was some effort to kind of show off, yeah, I stole the motorcycle, ha, 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 and I can get away with it, and you can't stop me. Well, they were wrong. He got stopped. No one, I guess, was expecting a gun to be brought to this thing. So how does this play out ultimately? This case is not going to be made or broken by this particular witness, because obviously this witness shows up after everything happened, and he's relying on what the defense argued was supposition based on what other people are telling him. And I think that's a very good point that was made in the cross-examination. We're going to have to wait and have to see what the other witnesses say. But again, the takeaway from the defense is, hey, what did you guys charge him with when you first had the opportunity? Oh, yeah, involuntary. How's that going to play out? In a way, the prosecution strength witnesses are always going to be your police officers. And in this case, that's sort of a weakness for the state, because they don't have the cops coming out right away and saying this is an absolute intentional murder and this is an absolute intentional act.
Yeah, I want to take a pause from our discussion here and bring in the 911 call that was placed, because that was played in court. We have that. I want to listen to that before we wrap up the day. Okay, Gary, you just listened to that, and I think you read it along with me. Look, it sounds like it's frantic. There's a frenzy going on, but maybe this is just me, but I listened to that, and it almost sounds like two different versions of a story happening in real time. You hear the daughter
Karen.
saying that the guy on the bike almost ran over her husband, and then you hear the father grab the phone and say he tried to run over my daughter. Okay, well, which one did he try to run over? He only went one way once, and in the process of, in the defense theory, coming back around or losing control of the bike in the state's theory, that's when the guy got shot. So it's like, who did he try to hit here? I mean, is this a case where you've got a defendant trying to sort of clean up the narrative immediately or not?
And in real time. I mean, again, going back to the argument about how technology is changing the way cases are prosecuted. So Karen makes the 911 call, okay? And then as she's trying to explain what's happening, her dad is listening, and as soon as she's going in a direction he doesn't like, he steps in and literally steps over her and starts trying to change the narrative of what she just saw. And for the prosecution, that's going to be very helpful. It's going to be a problem for the defense because obviously Michelle is somebody who's reporting what's happening and being corrected now by her dad, the defendant.
Yeah, that's a really interesting clip. I know some of it's a bit inaudible. I wish that we had a better transcript, but we were trying to transcribe it on the fly here at Law and Crime. Maybe a few people picked up a few other words listening at home than we were able to pick out here. But want to listen to a little bit more here. This is some other previous testimony from an Akron police officer getting the dispatch call that shots were fired.
And this all occurred on Dan Mead Avenue in Akron, Summit County, Ohio. Is that correct?
Correct.
May I have just 1 minute here? No further questions.
Patrolman, if I ask you a question and it's a little vague, it's tough, or if it's tough to understand, I'll be glad to repeat it. Is that fair?
Yep.
Can you keep your voice up a little bit, sir? You're kind of soft-spoken.
Sure.
You get a call from dispatch said shots fired. Is that correct, sir?
Correct.
And that usually causes several cruisers to head to that location. Is that a fair way of putting it?
Yes.
Okay. Now, we heard a 911 call. You were listening to that 911 call?
Yes.
All right. And during the middle of that 911 call, did you hear a male voice, Mr. Knight, say that someone tried to run down his daughter?
I believe that was just stated in the 911 call, yeah.
Okay. Then, now, when you approached the scene, you saw, take this as fact, that Mr. Johnson is laying in the street by the pickup truck. Is that correct?
Correct.
People are pointing toward a red pickup truck and a person that turns out to be Mr. Johnson. Is that correct?
Yes, they're motioning to the older white male, Mr. Knight.
All right. Now, you approached Mr. Knight, correct?
Yes.
Are you the first officer to approach Mr. Knight?
My partner was next to me, but I was probably the closest to Mr. Knight.
Right. As you approach Mr. Knight, does he attempt to run or evade you?
No, sir.
Is your command, your first command to Mr. Knight to show me your hands or something to that effect?
Yes.
Does he comply?
He did not seem to make any more or less motions. He was just standing there.
All right. He didn't seem to hide anything, did he?
No.
In terms of, did you ask about a weapon?
I believe so.
Did Mr. Knight tell or show you where the weapon was?
Yes.
And this is minutes after the incident. Is that a fair way of putting it?
Yes.
You found a holster when you patted down Mr. Knight, correct?
I don't recall the holster and where it was on his person.
Okay.
But as the individual patting him down, I'm supposing that I would have been the one to, find it.
All right. These fast loaders. Was there any indication that night that those fast loaders were ever used?
Not to my knowledge.
Patrolman, thank you very much.
No further questions.
Thank you, officer.
Okay, so there's some testimony from one of the patrol officers who had direct dealings with the defendant just around the time of the shooting and at the time of his being handcuffed and led to a cruiser. Attorney Gary Gerstenfeld, what do you think? The defendant making statements as he's being cuffed and led away that he's worried about his family and says some guy tried to run down my daughter/family. Do we take him at his word, or do we assume that he's trying to spin the narrative to deflect blame from himself?
Well, again, it depends whose ox is getting gored. From the prosecution point of view, yeah, he's changing the narrative from the 911 call, and he's trying to put the case in his best foot forward. What is interesting, again, the problem the prosecutor is going to have is that it appears, and I can't say whether Officer Preston is called in to make any decisions on this. He's a pretty young police officer, but clearly the police department at least appears to have bought the story insofar as what they actually charged him with. And then again, the politics and the narrative and perhaps the optics of this case changes, and then we see the more serious charges that he's dealing with now. So how does that work? Well, a couple things. Number one, Mr. Knight is talking to the police right away. He's not acting, he's not trying to hide anything, he's not trying to conceal anything, and he's already explaining his what happened. And that account of what happened has remained fairly consistent from the point where the officers first get in touch with him, and even really back to that 911 call.
Exactly. And, look, this is a case that's not so much about facts, but it's about characterizations of facts, it seems. I mean, we know that he's the guy that pulled the trigger. He admitted it. And all the evidence points that he's the guy that pulled the trigger. It's a question of, how do we term this? Do we term it as self-defense, as Ohio law reads? In other words, self-defense of others is rolled up in the self-defense definition. Do we call it assault with a firearm? Do we call it murder? Do we say that the notion of self-defense just wipes all of that away? This, I think, just becomes one of those really hard cases because it calls on the jury to characterize facts rather than determine which facts are the true facts. So, Gary Gerstenfeld, attorney out of Washington, D.C., always great to have your analysis here on Law and Crime.
My pleasure. Have a good one.
All right. We're going to wrap up the broadcast today here on the Law and Crime Network. A reminder that we are on the air from at least 9 a.m. until at least 5 p.m. Monday through Friday with live coverage of trials. We will see you back here tomorrow at 9 a.m. with the William Knight case. For now, this is Aaron Keller, and for everybody here at Law and Crime, have a great evening.